Yes, Mr. Watkins.
My Lords, I appear on behalf of the appellants, who are the second to sixth defendants below. My learned friends, Mr. Mallin, King's Counsel, and Mr. Lewis, appear for the respondent, Sandman Property Management Limited, which was the second claimant below. There are two appeals before your lordships, which give rise to four main topics. Appeal 1 contains three of those topics. Did the appellants breach the unless order, relief from sanction, and strikeout? And then appeal 2 is the fourth topic. And there are also a couple of cost points which I'll cover briefly if I've got any time left at the end. But I'll start with the first topic, which is whether the appellants breached the unless order. And to be clear, we're putting to one side the 22-minute delay in serving the report. As my lords have seen, that was a breach, but the judge granted relief from sanction, and there's no appeal by the respondent against that decision. So when I say breach, I mean breach other than the 22-minute delay point. And there are three potential breaches to consider. The first is breach in respect of the instructions. The second is breach in respect of the report. And the third is breach in respect of the schedule. And I put them in that order because that's the chronological order. The judge, as my lords know, held that there was no breach in respect of the instructions and no breach in respect of the report, but he held that there was a breach in respect of the schedule. And of course, I say that he was wrong to hold that there was a breach in respect of the schedule. And my learned friends say that the judge was wrong to hold that there was no breach in respect of the instructions or the report. That's paragraph 1 of their respondent's notice.
It's not accepted below that you were in breach.
My lord, no.
No.
And I'll come to that. I make three preliminary observations. First, the issue of breach involves a question of interpretation regarding the proper construction of the relevant orders. And the key question of construction is, what did the unless order require the appellants to do? The second preliminary observation is that the appeal against the judge's decision on this issue is therefore not an appeal against an exercise of discretion. The fact that it's got nothing to do with discretion is clear from the decision of my Lord Justice Lewison in a case called Atrium, which your lordships will find in the authorities bundle. If I could ask you to turn it up, it's at tab 7, and the relevant paragraph is paragraph 40, which is on page 268 of the authorities bundle. And my lords will see that in the bottom half of page 268, paragraph 40, my lord said, I agree with the liquidators that the question whether the unless order was complied with is a case management decision in the sense that it is a procedural decision, but I do not agree that it is discretionary. Either the order was complied with or it was not. That is a question of interpretation of the order and the rules and their application to the facts. In my judgment, the omission to list the scripts was a clear case of failure to comply with the unless order. And so it follows that my learned friends are wrong to say in paragraph 5 of their skeleton argument that this is an appeal against a discretionary case management decision. That's incorrect insofar as the first topic is concerned. The third preliminary observation is that there is in this case a further issue of interpretation of the orders, and that is whose online accounts should the third-party e-disclosure provider Concilio have imaged? And specifically, was the imaging obligation confined to the online accounts of Mr. Ginder, or did it also cover Mr. Skinner and Mr. Cohen? And that's a distinct question of interpretation of the orders, which features in the arguments about breach, relief, and strikeout. I'm going to deal with it as part of the argument about construction of the orders. So having made those preliminary observations, my lords, I propose to make my submissions on this topic in 4 parts. First, I will deal briefly with the background to the relevant orders. Secondly, because it is a question of interpretation, we will have to look fairly closely at the terms of the orders themselves. And then thirdly, we'll turn to consider compliance and or non-compliance, to put it neutrally for present purposes. In other words, what did the appellants actually do in their attempts to comply with the unless order, and did their efforts fall short or not? And then fourthly, we'll look at the judge's reasoning in the judgment. So turning to the background, my lords, I don't need to tell you anything about the underlying claim or the defence at this stage. The judge described those matters in paragraphs 4 to 9 of his judgment in the core bundle at tab 3, and for present purposes, I don't really need to add anything to his summary. The first thing that I need to show your lordships is the DRD, which your lordships will find in the supplemental bundle at tab 21. This is starting at page SB 162. And there are four things that I need to show your lordships in the DRD. The first is at page 170, where in the left-hand column, the name column after the number, my lords will see the words electronic files, data sources / locations. And then in the right-hand column, I pick up in particular 2, desktop computer used by Samuel Ginder, personal laptop used by Sam Ginder, 3, 1x mobile phone used by Samuel Ginder, 5 references to Office 365 and G Suite, Google, and then 6, Microsoft OneDrive. That's the first thing. Then the second on the next page, page 171, my lords will see in the right-hand column geographical locations, 122 Colmore Row, and then the home address of Mr. Ginder. The third thing is on page 173. This is an important one for reasons that we'll go into in due course. Custodians and date ranges. And in the right-hand column, a total of 8 custodians. We've got Ginder, Skinner, Cohen, Farouk, Sanderson, Badger, Morehouse, and Daly. And then fourthly and finally, on page 176, my lords will see in the final row, irretrievable documents, none anticipated. We then come to the appellant's disclosure certificate, which my lords will find in the supplemental bundle at tab 22, starting at SB 179. My lords will see this is dated the 11th of January 2023. And if your lordships look at the second page, the only thing I need to mention for present purposes is paragraph numbered 3 in the bottom half of the page, which explains that Mr. Cohen's documents proved to be irrelevant and that he had been removed as a custodian during the disclosure exercise. So although Mr. Cohen was mentioned in the DRD, he's since been removed and he's no longer a custodian at all.
Sorry, where do we see that?
Paragraph numbered 3 on page 180.
Yeah, the review team decided to exclude Mr. Cohen's source document.
Precisely, my lord. The next point in the chronology is the 30th of January 2023, so the end of the same month, when the appellants gave supplemental disclosure of documents from Mr. Murray Twin, including emails between Mr. Murray Twin and Mr. Ginder, which had not previously been disclosed by the appellants. And that discrepancy inevitably prompted some questions from the other side solicitors, Shakespeare, Martineau. My client solicitors at the time, Jury O'Shea, responded to those questions, and my lords will find this at tab 25 of the authorities bundle, supplemental bundle, misspoke, at page, in the same supplemental bundle, tab 25. Page 199, and it's really only the final paragraph on that page that I need to show the lordships. As to paragraph 2.4, there's very little correspondence from Mr. Ginder because this is not the way he operates. He conducts business on the telephone and video meetings or in person, rather than by electronic or hard copy correspondence. Further, Mr. Ginder's practice was and had been to routinely delete his emails at the end of each day. To the extent that documents were not included in the substantive disclosure as per your description, but appeared in Mr. Murray Twin's disclosure, Mr. Ginder can only assume that those emails were deleted as per Mr. Ginder's practice. Now, Shakespeare Martineau did nothing with that information until 6 months later when they asked some further questions, but Jury O'Shea didn't respond. And then nothing happened for a further 5 months until the 13th of June 2024, when the respondent applied ex parte without notice for the imaging of Mr. Ginder's devices and online accounts. And what the respondent was seeking was explained by solicitor Mr. Wolstenholme of Shakespeare Martineau. My lords will find this in the supplemental bundle at tab 12. The statement starts at page 71, but we can pick it up at page 75.
Tab 12.
It's tab 12, my lord, in the supplemental bundle again.
Yeah.
And as I say, we can pick it up at page 75, where my lords will see in the bottom half of the page, paragraph 20, there's the quote from the Jury O'Shea letter with some italics and it's in bold text and underlining for emphasis. And then in paragraph 21, he says this was the first time the defendant had made reference to the practice of deletion by Mr. Ginder. It seems to be accepted in the letter from Jury O'Shea that there would have been more disclosable documents originating from Mr. Ginder, and of course I emphasise those words, but that these had been deleted. And then Mr. Wolstenholme explains that the respondent is applying for the images of Mr. Ginder's devices and online storage accounts, not Mr. Skinner's or Mr. Cohen's or anyone else's, Mr. Ginder's. The respondent wanted the court to order that Mr. Ginder's devices and online storage accounts be imaged by the respondent's IT expert from BDO. And my lord will see that it's particularly clear from page 77 under the heading without notice order, where it says the claimants have cause to believe that there may be relevant documents to include emails that are relevant to this matter and which should have been disclosed, which have not, by virtue of them being deleted or otherwise made unavailable for disclosure. In such circumstances, the claimants seek permission from the court to instruct the expert to forensically image Mr. Ginder's devices / online storage accounts to determine whether any documents which have been deleted can be restored and retrieved. Those devices / online storage accounts should be those as set out in the DRD and above, namely the following. And then the list is set out in subparagraphs 1 to 6, including in 4 Office 365, 5 G Suite and 6 Microsoft OneDrive. So when Mr. Wolstenholme says those devices and online storage accounts should be those as set out in the DRD, and he mentions Office 365, G Suite and Microsoft OneDrive, he's clearly describing Mr. Ginder's devices / online storage accounts. Those are the words he's just used, not those of any other custodian. And that's confirmed by subsequent passages in this witness statement, which show that the respondent was seeking the imaging of Mr. Ginder's devices and online storage accounts, not those of any other custodian. And I give your lordships 3 particular references. First, in page 78, paragraph 32, my lords will see the form of order sought provides only that the devices and online storage accounts will be provided and or made available to BDA for the imaging process, after which they will be returned to Mr. Ginder or his solicitors within 48 hours. It's submitted this will cause minimal disruption or prejudice, if any at all, to Mr. Ginder, etc. Then secondly, the same page, paragraph 34, first, it may be said that there's no risk of deletion that requires the court to grant a preservation order or to require the third defendant, that's Mr. Ginder, to hand over his personal and business devices to a third party. And then thirdly and finally, on page 79, where Mr. Wolstenholme says in terms that the respondent was not seeking to image anything belonging to Mr. Skinner or Mr. Cohen, that's paragraph 39, where it's said by Mr. Wolstenholme that the third defendant, Mr. Ginder, may say that the requirement for him to hand over his personal devices or business devices causes him prejudice in his working life. And then in the final line, moreover, the business of the second to sixth defendants can continue while the third defendant's devices are with BDA, because there are at least two other persons working with the third defendant on various projects, as shown in the custodians recorded in the DRD. And those two other persons are, of course, Mr. Skinner and Mr. Cohen. What Mr. Wolstenholme is saying there is that the business won't be disrupted because the imaging order won't affect Mr. Skinner or Mr. Cohen. The order that the respondent was seeking is at tab 7 of the supplemental bundle. And we can start at page 40. And I should say, although this is, of course, only a draft order, I do need to show you what they put before the court, as it helps to make sense of subsequent orders. Paragraph 1 on page 40 is the injunction against Mr. Ginder alone. And paragraph 3 is then the imaging order. And my lords will see that it refers to the imaging of electronic storage media, which are the devices, and then online storage accounts. And in paragraph 3b, my lords will see it requires Mr. Ginder to supply to the independent computer specialist all the login credentials for the online storage account. And the terms in use there are defined on page 41, the very next page, where my lords will see that in E, online storage accounts means the Office 365 and G Suite email servers and Microsoft OneDrive as identified in section 2 of the DRD and any backup or archive system of emails in place from 1st November 2019. And although it's not spelt out particularly clearly, that is plainly intended to be a reference to the online storage accounts of Mr. Ginder. That's what Mr. Wolstenholme has said in terms in his witness statement, including in paragraph 28, which you've seen. And then that's confirmed by G, login credentials, because that's all relevant passwords, etc., in the final two lines, in the knowledge, possession, or control of the third defendant, not in the knowledge, possession, or control of Mr. Skinner or Mr. Cohen, or indeed any other custodian. And this is also clear from paragraph 4 of the draft order, back on the previous page. My lords will see 4A and 4B. And 4A is return the electronic storage media to the third defendant, that's Mr. Ginder. And 4B at the top of the next page is hold the forensic images and keep them safely in his custody to the order of the court or agreement of the third defendant. So again, that's Mr. Ginder having control over the images because they're the images of his online accounts. And while we're here, you can see that 4B includes a term forensic images. That is defined in F on page 41. It's simply the images that are taken by the independent computer specialist. I think that's as much as we need from this draft order. The fact that the imaging sought by the respondent was limited to Mr. Ginder's materials is also clear from the skeleton argument that was put before the court at the ex parte hearing. And I believe your lordships should have that in the same supplemental bundle behind tab 28.1.
Tab 28, did you say?
Tab 28.1, I believe, my lord. It may be all behind tab 28. I'm afraid I don't have hard copy bundles myself, but it's page 216, using the page numbering. Yeah. Now, my lords will see it's clear as day from paragraph 1. This is a without notice application made on behalf of the claimants. The principal relief sought is to permit specialist forensic experts at BDA to take forensic images of various computer devices held by Mr. Ginder, the third defendant. No mention of Mr. Skinner or Mr. Cohen. And in the event, His Honour Judge Worcester was not persuaded to make an imaging order ex parte. Instead, he made an injunction restraining Mr. Ginder from deleting any further documents and said that the application for an imaging order should be renewed on notice at an inter partes hearing. And the order of His Honour Judge Worcester is at tab 3 of the supplemental bundle. We can start at page 11 just to identify the order. But my lords will see the body of it on page SB 12, paragraph 1, is an injunction against Mr. Ginder, essentially to restrain him from deleting any further disclosable documents. And while we're here, at the bottom of page 12 are some definitions. Over the page that they continue, page 13, my lords will see the definition at the top of the page of online storage, online storage accounts. That's the definition from the draft order, and again, although it's not spelled out particularly clearly, that's obviously a reference to the online accounts of Mr. Ginder. So that's the background. I'll move on then to the relevant orders themselves, and there are two of them. The first is the order of His Honour Judge Rawlings at the inter-parties hearing on the 3rd of July 2024, which you'll find in this supplemental bundle at tab 4, page 14. And this is important because this is the order to which the subsequent unless order cross-refers. And I'm going to make submissions on paragraphs 2, 3, 4, 5, and 6 of this order. But just to highlight it at this stage, the unless order that was made subsequently on the 31st of July relates only to paragraphs 3, 4b, and 5. There were never any unless terms imposed in respect of paragraphs 2 or relevantly for present purposes 6. And we can start with paragraph 2 on SB 15, which, as I've said, was never subject to unless terms. This is the imaging order. It's essentially the same as the previous draft that you've seen, but instead of the image being taken by an independent computer specialist from BDO appointed by the respondent, it was to be taken by the appellant's own e-disclosure provider, Concilio, which had helped the appellants to conduct their disclosure exercise back in 2022. And in the fourth line of paragraph 2, my lords will see that Mr. Ginder has to, by 4 p.m. on the 5th of July 2024, give the e-disclosure provider effective access to the electronic storage media and online storage accounts. The definition of online storage accounts is on page 20, and it's the definition that it's in J, towards the top of the page, third entry down. It's the definition that your lordships have seen already, with one addition. In the final line, the words "and the email account identified at paragraph 6C. Those words are new. Paragraph 6C, just to go back to it, is on page 17. And my lords will see at the top of the page that there's a reference in C to the third defendant's email address, sam@futurehighstreetliving.com. So that...
I wasn't keeping up. Can I just...
Sorry.
We were in...
I'm sorry, my lord. We were at page 20.
Yes.
We were looking at the definition of online storage accounts.
And the addition was...
In the final line of the definition and the email
Yes,
account
yes.
identified in 6C. That's then back at the top of paragraph 17.
Yes.
And it is the third defendant's email address, sam@futurehighstreetliving.com. And that addition simply confirms in my submission that we're dealing with the online accounts of Mr. Ginder rather than any other custodian. If it had been concerned with any other custodians, then it would have also added expressly in the same way Mr. Murray Twin, who had become a custodian subsequent to the DRD. His account wasn't mentioned in the DRD. He became a subsequent custodian. If the intention was to include further custodians other than Mr. Ginder, then Mr. Murray Twin would obviously have been mentioned expressly, and the order would have also made clear expressly that it didn't cover Mr. Cohen, who ceased to be a custodian a long time ago. fact that it's Mr. Ginder's devices on online accounts is also confirmed by three other definitions that my lords will find on page 16, sorry, page 7, page 19, sorry, mistaken my note. A, deletion practice, showing in the practice by which the third defendant is said to have routinely deleted his emails, as described in the letter from Jury O'Shea. B, SG devices, that's obviously Sam Ginder devices, and that term is defined to include the online storage accounts.
And when you say obviously, you mean because it says SG?
SG, my lord, yes, I don't think there's any dispute about that. SG is Samuel Ginder.
Yeah.
And that includes the online storage accounts. And then over the page, login credentials, again, it's a point previously made in L, final words, it's a passwords, etc., in the knowledge, possession or control of the third defendant. Now that's the imaging obligation to which no unless terms were added. As I've said, the paragraphs to which unless terms were added are 3, 4b and 5, and it's convenient to address them together. In broad terms, paragraphs 3, 4b and 5 required the appellants to give instructions to the disclosure provider about 3 things and serve 2 things. And I'll start with the 3 instructions. The first set of instructions, my lord will find in paragraph 3, which is back on page 15, bottom half of the page. This is the first set of instructions that the appellants are required to give. 3, the 2nd to 6th defendants shall instruct the disclosure provider to, and then you find A to F, various tasks. The appellants have to give those instructions to the disclosure provider. The second set of instructions over the page, on page 16, this is paragraph 4, B, the first 2 lines of 4b, the 2nd to 6th defendants shall also instruct the disclosure provider to produce a report setting out the steps the disclosure provider has taken pursuant to the instructions under paragraph 3. So that's the second set of instructions. The appellants had to instruct the disclosure provider to produce a report. And then the third set of instructions, also in 4b, starting at the end of line 2 through to line 7, also instruct, that's the end of second line of 4b, also instruct the disclosure provider to produce a schedule containing the following details. And one is the file name of any document deleted or modified following service of the initial order. To save you having to turn up that term, it's defined on, in the third recital on page 14. It's the injunction of His Honour Judge Worcester, dated the 18th of June 2024. So they have to instruct the disclosure provider to produce a schedule containing the following details. 1, the file name of any document deleted or modified following service of the injunction of His Honour Judge Worcester, which restrained Mr. Ginder from deleting any further documents. 2, the file type of any document identified. 3, the date and time of such modification or deletion or access of the SG device. 4, any identifiable user or profile undertaking such a step. 5, any identifiable steps taken during such access of the SG device, and that's defined as the schedule. So the third set of instructions are instructions requiring conciliator to prepare a schedule, and as you've seen, the principal, in fact, we would say sole purpose of the schedule is to police the injunction granted by His Honour Judge Worcester. So those are the 3 sets of instructions. There's a clear common feature. The order required the appellants to give instructions. That's what they were ordered to do. My lords have seen paragraph 3 shall instruct, paragraph 4b line 1 shall also instruct, and then paragraph 4b line 2 also instruct in respect to the schedule. And as I've said, what you also find in these paragraphs is a requirement to serve 2 things, the schedule and the report, the requirement to serve the schedule is at the end of paragraph 4b. There's an opportunity to redact anything privileged, but that doesn't give rise to any issues in the present case. And then the final sentence of 4b, the second to sixth defendant solicitors will then provide a copy of the schedule to the claimant solicitors, incorporating the permitted redactions by 4 p.m. on the 19th of July 2024. And then the requirement to serve the report is in paragraph 5 on the same page. The second to sixth defendants shall serve a copy of the report produced under paragraph 4 on the claimants by 4 p.m. on the 23rd of July 2024. So that's what you find in paragraphs 3, 4b and 5. And how do you comply with paragraphs 3, 4b and 5? In our submission, it's straightforward. You have to give the instructions specified in paragraphs 3 and 4b, and you have to serve the report and schedule produced by the disclosure provider on the other side. And if you give the instructions specified in 3 and 4b, and then you serve the report and the schedule produced by the disclosure provider, you have complied. Before we leave this order, I need to show you paragraphs 6 and 7. Paragraph 6 is about further disclosure. It's about conducting further searches. And as I said, there was never any unless order attached to this. And then importantly, for reasons that we'll come to on the next page, page 17, paragraph 7, the parties shall agree reasonable extensions to the period set out above and shall agree reasonable refinements to the searches once the second to sixth defendants have ascertained the number of target documents, further documents and other documents on the forensic images and the number of such documents which are responsive to the searches, so as to limit the requirement for manual review so far as reasonably practicable. So paragraph 7 makes clear that this isn't set in stone. The parties are under a positive obligation to agree reasonable refinements once the picture has become clearer, so as to limit the requirement for manual review so far as reasonably practicable. So that's the first of the two orders. The second relevant order is the unless order, which my lords will find at tab 5 of the supplemental bundle, page SB 23. Is the operative provisions. It starts on page 22. It's dated the 31st of July 2024. But as I say, the relevant paragraphs, the operative provisions on page 23. And paragraph 1, my lords will see, begins, unless the second to sixth defendants have instructed the disclosure provider to take the steps set out in paragraph 3A to E of the order of Honour Judge Rawlings dated 3rd of July, by 4 p.m. on the 2nd of August, and then the sanction is set out. So the sanction there takes effect unless by the deadline the second to sixth defendants have instructed the e-disclosure provider to take the steps set out in 3A to E. And then 2, unless the second to sixth defendants have complied with paragraph 4B of the order by 4 p.m. on the 16th of August. So under that paragraph, the sanction takes effect unless by the deadline the second to sixth defendants have A, instructed the e-disclosure provider to prepare the report and the schedule, and B, served the schedule. And then 3, unless the second to sixth defendants have complied with paragraph 5 of the order by 4 p.m. on the 9th of August, etc. So under paragraph 3, the sanction takes effect unless by the deadline the second to sixth defendants have served the report. So my lord, so those are the orders. We can now move on to compliance and or non-compliance. In other words, what did the appellants actually do in their attempts to comply with the unless order, and did their efforts fall short or not? And I can deal with this in 3 parts. 1, instructions, 2, report, 3, schedule. So dealing with the
So you say paragraph 4.3 and 6 of the 31st July are not relevant.
Sorry, my lord, say it again.
You say, do you, that paragraphs 4.3 and 6 of the 31st of July order are not relevant?
Not to any of the issues in this appeal, not to the judge's reasoning or anything found in the grounds of appeal or the respondent's notice.
Right.
So, yes, I think we can move on to compliance or non-compliance. Instructions are in the supplemental bundle tab 29. We start with page 231, an email from Gemma Williams of Jury O'Shea to James Wilson from Shakespeare Martineau, claimant solicitors, attaching the draft letter of instructions to Concilio. And the draft letter is being sent over for comments. The draft letter of instructions itself is on the next page, 232. And paragraph 2, which starts towards the bottom of page 232, contains all the instructions required to be given by paragraphs 3 and 4b of the order of the 3rd of July. One can just look at that over onto page 233. I'm not going to read it out, but it contains everything required to be given by paragraphs 3 and 4b, to which the unless terms were attached. I should, of course, also mention while we're here, paragraph 1 on page 232, which contains the instructions about imaging in terms which reflect accurately paragraph 2 of the order of the 3rd of July, although as you've seen, no unless terms were ever attached to that. We can then move to tab 30 at page 235, where Shakespeare Martineau respond, providing a markup of the instructions that begins at page 238. And my lords will see that they've made no changes to paragraph 1 and no particularly major changes to paragraph 2. Paragraph 2 continues to contain all the instructions required to be given by paragraphs 3 and 4b. And the final version of the instructions, my lords will find behind tab 37 of the supplemental bundle, right at the back, page 322 of the bundle. And again, paragraph 2 contains all the instructions that are required to be given by paragraphs 3 and 4b of the order of the 3rd of July. So that deals with the instructions. Next is the report. Concilio produced a report setting out what they've done. My lords will find that at tab 34 of the supplemental bundle, page 246. This is the report that was served 22 minutes late. And my lords will see from paragraph 248 at the top of the page, second paragraph, per paragraph 4b of the 3rd of July order, this report is to set out the steps that Concilio has taken pursuant to its instructions under paragraph 3. And the report then does that. Then the schedule, Concilio produced the schedule. I'll show you the first page. It's behind tab 35.1 of the supplemental bundle, page 266. It's in very small type, but I can tell you that the column headings include the items specified in paragraph 4b of the order. This was provided to the other side solicitors under cover of the email at page 264.
Sorry, the column headings include the matters.
Yes, exactly, as required by the instructions that we've just seen.
Yeah.
And the covering email is, I think it's the first document at tab 35. It's certainly page 264. That is sent to them on 16th of August at 3:45 in the afternoon. So having given instructions to Concilio to produce the schedule, the appellants then provided a copy of the schedule produced by Concilio to the other side solicitors before the date and time specified in the unless order. So the appellants did everything required of them by paragraphs 1, 2, and 3 of the unless order dated 31st of July by the relevant deadlines, save for the 22-minute delay in the service of the report from which relief from sanction was granted. Now, given the judge's reasoning on the issue of breach, I'm also going to have to explain the problems that arose regarding imaging. Mr. Ginder's devices were collected by Concilio. There's no issue that arises in respect of those. The problems related to Mr. Ginder's online storage accounts, and there were two problems. The first related to the data in the account sam@taylorgrange.com. And I can start by saying that Concilio and the third-party IT provider S2 did successfully locate and image sam@futurehighstreetliving.com, subject to a point that I'll come on to, but they found sam@futurehighstreetliving.com and it had data in it. That's the email address that we saw mentioned in paragraph 6C of the order of the 3rd of July. So they found sam@futurehighstreetliving.com and it had data in it. They also found Mr. Ginder's other email account, sam@taylorgrange.com, but it contained 0 bytes of data. It was empty. And what they concluded was that the emails in the empty sam@taylorgrange.com account had all been forwarded, synced, or migrated to sam@futurehighstreetliving.com, with sam@taylorgrange.com not retaining a copy. And I can show you that in Concilio's supplemental report in the supplemental bundle at tab 36. The relevant page is 318 of the bundle. And it's towards the bottom of page 318 in the final 3 lines. As highlighted previously and in the report, all online accounts which were identified in communications with the S2 group as related to Sam Ginder were collected. The S2 group informed Concilio and demonstrated that any available data would be contained within the sam@futurehighstreetliving.com mailbox due to forwarding, syncing, and migration. Over the page, specifically in relation to the sam@taylorgrange.com account, this account and its data, Concilio was informed that this was migrated to the Microsoft 365 environment where all emails were forwarded to the sam@futurehighstreetliving.com account, not retaining a copy in the Taylor Grange mailbox. To be clear, based on information provided to Concilio, it was not possible for the S2 group to make available or have forensically imaged the email server for sam@taylorgrange.com, as this account contained 0 bytes of data. No data related to this account exists to be imaged outside the M365 account, OneDrive, and email related to sam@futurehighstreetliving.com on the desktop computer. And then they say the picture copied below also highlights factually that the sam@taylorgrange account demonstrated that the account contained 0, open brackets, 0, close brackets, data. So they found sam@taylorgrange.com, but it was empty. It's not that they didn't look for it. They found it and it was empty. But then after the production of the schedule, they found a second version of sam@taylorgrange.com in a different electronic location. And the second one wasn't empty. And they explain that in the paragraph after the image on this page. After the collection of data in July 2024, an additional M635 tenant was identified, which does contain data relating to the sam@taylorgrange.com email account. And this data has been collected, processed, and searched as outlined in this report. And you'll also see that back on page 295 under the heading 8, Data Delivery, August 2024, where they say on 295, after the collection completed in July 2020, a second M365 tenant was identified by Edward Spencer, containing additional accounts detailed below. And over the page, just above the table on page 396, second sentence, in this second M365 tenant environment, the sam@taylorgrange.com email account was found to contain data, and references in this report to searches carried out on this email account refer to data obtained in August 2024. So that was the first problem. They thought they'd found sam@taylorgrange.com and it was empty, but in fact, unbeknownst to them, not discovered until later, there was a second version of it which did contain data. The second problem on imaging relates to the date range. And as my lords have seen, paragraph 2 of the order of the 3rd of July contains no date range, and there's no date range mentioned anywhere in Consilio's first report. I'll show you that in the supplemental bundle at tab 34, page 248. My lords can see here the penultimate entry on page 248. 10365 email account associated with the email address sam@futurehighstreetliving.com. For reporting purposes, this device is referred to as the email account. No mention of any date range. And then next page 249. Again,
Where are you seeing date range?
there's no date range mentioned. I'm showing, my lords, the absence of it. When we look at the supplemental report, we'll see that the information about the date range is revealed for the first time. So they mention the account that they've imaged, but they don't mention any date range. And the next page, it's precisely the same story, where in the penultimate bullet point, they say the email account and cloud storage account were extracted from the M365 platform using Microsoft Purview. There's no mention of any date range. So the first report contained no reason to think that Consilio had not emailed the whole of sam@futurehighstreetliving.com. What became apparent for the first time when Consilio provided its draft supplemental report on the 28th of July was that it had in fact applied a date range. And we can see that in the supplemental bundle at tab 36 at page 293, where now, top of 293, item number 3, one M365 email account associated with Sam Ginder, the email address is sam@futurehighstreetliving.com. It added the words, my lord, see, between 1st of October 29 to 31st of January 2023. That's new information. Similarly, at page 294, paragraph 3 is the sentence that we've seen, first sentence ending with the reference to Purview. And then there's a load of new information, including over the page in B, page 295, a forensic copy of the email account between 1st of October 2019 to 31st of January 2023 was exported to PST format. And the appellant's solicitor, Ms. Williams, confirmed in a witness statement verified by a statement of truth that she had no prior knowledge of this. My lords will find that in the supplemental bundle at tab 20 at page 157. Where it says in paragraph 11, Consilio, sorry, I'll wait for my lords to turn it up, it's page 157. Paragraph 11, Consilio did not mention to me that they had only processed the account 31st of January 2023 until we received a draft of their supplemental report on the 28th of August 2024. So when the judge says in the judgment, at the end of paragraph 58 and in paragraph 73 and in paragraph 76G,
Sorry, 58.
73, 76G, he says it was clear to Ms Williams from Concilio's first report that they had only processed the account up to the 31st of January 2023. That is simply wrong. That information was not contained in the first report. It was not disclosed to Ms Williams until Concilio circulated their draft supplemental report on the 28th of August. And we do, of course, accept that there were problems relating to imaging. I've just described them. And what happened was unfortunate, but none of that amounts to a breach of the unless order, because the appellants did what was required by the unless order for the reasons I've explained, and the fact that there were problems in respect of imaging doesn't alter that conclusion. So then, my lords, I turn to the judgment. This is the judgment in the core bundle. So I can ask my lords to put away the supplemental bundle. It's at tab 3 of the core bundle. And I'm going to deal first with what the judge said about the instructions in the report before looking at what he said about the schedule. So we can start in the core bundle on page 17. Where my lords will see before paragraph 26 is a heading, has the unless order been breached so that the sanction applies. And then towards the bottom of page 17, just before paragraph 29, has paragraph 1 of the unless order been breached. And as you've seen, paragraph 1 relates to paragraph 3 of the order of the 3rd of July, which required the appellants to give instructions to Concilio to do the things set out in subparagraphs A to E, and the judge sets that out in paragraph 29. And then in paragraph 34 on page 19, he says that he is satisfied that the defendants have breached the requirements of paragraph 2, that's the imaging order, to which no unless terms were ever attached. And then, crucially, however, paragraph 35, next paragraph, he says, I am not, however, satisfied that the defendants have breached paragraphs 3A to E of the 3rd of July order, to which the unless order attached the sanction. And he explains why. And the key points in his reasoning are in C and E over on the next page. In C, he says paragraph 3 of the 3rd of July order requires the defendant simply to instruct Concilio to carry out steps A to E. The defendants had no responsibility under that order to ensure that Concilio carried out those steps. And then E, in my judgment, applying the ordinary meaning of the words in paragraph 3 of the 3rd of July order strictly, the defendants complied with it if they gave to Concilio the instructions required by that paragraph to be given to Concilio within the time allowed, and it is common ground that they did both of those things. The fact that Concilio had not imaged all the online storage accounts that they ought to have imaged does not mean that the instructions that the defendants were required to give to Concilio by 4 p.m. on the 2nd of August had not been given. And my lords, that's entirely correct. My lords have seen paragraph 3 of the order of the 3rd of July. It required the appellants to give instructions to Concilio. They did so. It follows that they complied. Now, my learned friends invite your lordships to overrule the judge on this point. Their argument is convoluted and wrong, but it's convenient for me to deal with it at this juncture. They start with the definition of forensic images with a capital F and a capital I, which my lordships will find. I'm afraid we do need to go back to the supplemental bundle for these purposes. It's it's page 20 of the supplemental bundle. That's afraid I don't have a note of what tab that is, but hopefully it won't be too difficult for your lordships to find because it's page 20. This is in K on page 20, forensic images, and my learned friends rely on the words in accordance with paragraph 2 above. They say that if the taking of the forensic image doesn't fulfill the requirements of paragraph 2, then the resulting image is not a capital F forensic capital I image within that definition, because it hasn't been taken in accordance with paragraph 2. And my learned friends then rely on the cross-references to capital F forensic capital I image, which you find in subparagraphs A, B, C, and E of paragraph 3. And they say that if there's no capital F forensic capital I image in existence, then the appellants cannot give the instructions required by paragraph 3 because of the cross-references in paragraph 3 to capital F forensic capital I image. My learned friends, in other words, say that it was essential for the appellants to comply with paragraph 2, to which no unless terms are attached, before they could comply with paragraph 3, to which the unless terms have been attached. They say that if the appellants hadn't yet complied with paragraph 2, then it was impossible for them to comply with paragraph 3. Now that's wrong for the reasons given by the judge, and I make 3 points to show why the judge was correct on this issue. First, my learned friends are wrong to say that compliance with paragraph 3 is critically dependent on prior compliance with paragraph 2. There's no basis for saying that the appellants had to comply with paragraph 2 first before complying with paragraph 3. There would have been absolutely nothing to stop the appellants from providing concilio with the instructions set out in paragraph 3 before they had provided effective access to concilio under paragraph 2. So, for example, the appellants could have given the instructions under paragraph 3 at, say, 10 a.m. on the 5th of July before giving effective access to concilio at, say, 3 p.m. on the same day. So compliance with paragraph 3 is not dependent on prior compliance with paragraph 2. And secondly, by saying that compliance with paragraph 3 depends on prior compliance with paragraph 2, my learned friends wrongly allied paragraph 2 with paragraph 3. They collapsed them into a single provision. And it's clear why they seek to do so for tactical reasons, because no unless terms were ever imposed on paragraph 2, but it's wrong for the same reason. No unless terms were ever imposed on paragraph 2. Yet the effect of my learned friend's submission on this point is that it would have made no difference whatsoever if unless terms had been applied to paragraph 2 or not. They say it makes no difference whether you apply unless terms to paragraph 2 or not. But the fact that no unless terms were ever imposed on paragraph 2 means that a breach of paragraph 2 is not a breach of the unless order, as the judge held. It's wrong to try to allied paragraphs 2 and 3 of the order of the 3rd of July. The fact that an unless order was made in respect of paragraph 3 of that order, but not in respect of paragraph 2, means that it is essential to consider each of them separately. And the third point, in any event, the premise of my learned friend's argument on this point is wrong. There's no basis for saying that an image taken in partial but incomplete compliance with paragraph 2 is not a capital F forensic capital I image. Your lordships have seen the genesis of that definition in the draft order. The words "in accordance with" are merely cross-referential. They simply point you to paragraph 2. And in this context, they mean no more than under or pursuant to. They don't, by a side wind, import some wholesale requirement for strict compliance with paragraph 2. An image taken in partial but incomplete compliance with paragraph 2 will still be a capital F forensic capital I image within the definition. And my lord saw the draft order sought ex parte. If BDO, if the court had made an order in those terms, and then BDO had imaged 90%, say, but had overlooked the remaining 10%, the resulting images taken by BDO would still have been capital F forensic capital I images, and the same conclusion applies when the imaging is to be done instead by concilio. So that deals with the instructions in paragraph 3 of the order of the 3rd of July. We invite you to hold that the judge was right for the reasons that he gave. to say there was no breach of paragraph 3. We then come on to the report, and the key reasoning is back in the core bundle at tab 3, I think it was, page 24, where the judge says in, my lord should see, just page 24, just before paragraph 59, there's a heading, has paragraph 3 of the unless order been breached, other than by the report being served 22 minutes late. So this is the report now. And the key reasoning is in paragraph 60 and 61. In 60, the judge says paragraph 4b required the defendant to instruct conciliator to produce a report setting out the steps it had taken in relation to the tasks that the 3rd of July order required the defendants to instruct them to carry out. An instruction was given in accordance with paragraph 4b for conciliator to prepare a report setting out the steps it had taken. 61, the report does report on the steps conciliator had taken, it's just that they took them in relation to only one of the online storage accounts and then for the wrong period. There's no breach of paragraph 4b of the 3rd of July order because defendants gave conciliator the instructions that the paragraph required them to give to conciliator, and conciliator prepared a report upon the steps that they'd taken to comply with those instructions, which was served on the second claimant solicitors, albeit 22 minutes late. Again, my lords, we say that's entirely correct. The first 2 lines of paragraph 4b required the appellants to instruct conciliator to produce a report. The appellants did so. And then, in accordance with paragraph 5, they served the report that conciliator had produced. My learned friends seek to attack the judge's reasoning, and their argument is essentially a repetition of the argument that the judge records in paragraph 59 of the judgment. It was rejected by the judge correctly. It's a development of the argument about capital F forensic, capital I images, which I've addressed already, but it's even more tendentious because what my learned friends are trying to argue is that the partial or incomplete fulfilment by concilio of its instructions necessarily means that the appellants can't have instructed concilio to prepare a report setting out what it had done. But that's a complete non sequitur. It doesn't follow at all. So I invite your lordships to uphold the judge on this issue for the reasons that he gave in paragraphs 60 and 61. We then come to the schedule. And my lords, my submission is that the judge should have applied the same reasoning that he had applied already in respect of the instructions and the report. He should have held lines 3 to 7, paragraph 4b of the order of the 3rd of July, required the appellant to instruct concilio to produce a schedule. And the final lines of that paragraph required them to serve it on the other side. The appellants gave those instructions to concilio, and they served the schedule that concilio produced, and there was accordingly no breach. That reasoning would be obviously correct. It would be entirely consistent with what the judge had said about the instructions and the report. But the judge didn't adopt that reasoning. What happened instead was that the judge was led astray by the case law about requests for further information under Part 18 of the CPR. And as a result, he went wrong. And the problem in the reasoning starts on page 22, where we have the heading, has paragraph 2 of the unless order been breached? And in paragraph 47 on that page, the judge mentions some authorities to which Mr. Atkins had referred. And the second of those authorities in 47b is a case called Gravity Highway.
So let me just remind myself of what the order says. So he's now talking about paragraph 2 of the unless order.
The unless order.
Now, that requires compliance with 4b of the earlier order.
Yes, and he's talking about the schedule.
Right, so 4b requires the schedule to be served by 4 p.m. on the 19th of July.
it requires the instructions to be given to conciliate to
Yeah.
produce it, and then, my lord's absolutely right, the schedule to be served. And the judge isn't being terribly precise because, of course, we've seen in the first two lines of 4B, it's the report. When he says 4B, he means the remainder of 4B relating to the schedule. And he says in 45 of the judgment, a schedule was served in the time allowed by the less order, but it did not include documents from any email account other than sam@futurehighstreetliving.com up to 31st of January 2023, because only that email account for that period had been imaged by Conciliate. So he's talking about the schedule. And then where we say he starts to go wrong is in 47, where he refers to cases that have been cited to him. The second in 47B is a case called Gravity Highway.
Well, just before we go there,
Sure.
paragraph 4B of the 3rd of July order requires the appellants to give instructions.
Yes. So it's no different from 3 and the first two lines of
So-
4B.
Where in paragraph 46 of the judgment, the judge says that the schedule ought to have contained, but did not, details of documents deleted or modified. If I've understood your argument, you say, well, that doesn't matter
Exactly.
as long as the appellants gave instructions, the right instructions to Concilio.
Precisely.
By parity of reasoning with what the judge said on other parts of the order, if Concilio didn't carry out their instructions, that's not a breach by the appellants of what they were required to do under the terms of the order.
And
Is that right?
absolutely, but I go one step further than that, which is that if the reason the schedule is not complete and sufficient is because there's been some breach or other failure in relation to imaging in paragraph 2 of the order of 3rd of July, then it's still not a breach of any unless order because unless terms were never attached.
Yeah, no,
to
I understand
paragraph 2. So, my lord, that's absolutely right. And what I'm showing you now is where we say the judge was led astray by the authorities in relation to provision of further information under Part 18. And
You're
it's,
going to say all these authorities don't really matter.
my lord is more than one step ahead of me, but I'll show my lords what the judge says
It's a
first.
question of what the defendants were ordered to do.
Exactly.
So I don't understand this objective, subjective stuff.
Exactly.
You have to ask, what were the defendants ordered to do? Question 1. Did they do it? Question 2.
Yes, yes. I think I can take the next bit of my submissions a bit more quickly. We can look at what the judge said about Gravity Highway. My lord can see about halfway through paragraph 48, where the judge says, this is the end of the 3rd line, the test promulgated in the Gravity Highway case was whether the answers given to questions which the claimant was ordered to answer in that case were plainly incomplete and insufficient. And then over the page at 52, he quotes from Mr. Justice Butcher's decision in Gravity Highway. In assessing whether there has been compliance with an unless order for the provision of further information, and obviously I emphasise those words, the court will consider whether the information is plainly incomplete or insufficient, given the terms of the order as to the information to be provided. Again, I emphasise those words. And at the bottom of the page, the judge says, 56, I consider the objective test promulgated by Mr. Justice Butcher in Gravity Highway is the appropriate test here. And then over the page, paragraph 57, the judge says, the defendants accept the schedule ought to have contained details of documents which it did not contain. Even if I'd accepted the defendant's case that only 2 email accounts of Mr. Ginder had to be imaged, the schedule served was still plainly incomplete and insufficient.
You say what he's done illegitimately is he's jumped from the instructions that the defendants were required to give to the contents of the schedule that were ultimately produced.
Exactly. And my lord can see that from the repeated points in the judgment where what the judge holds to be a breach of paragraph 4B is what he describes as service of an incomplete and insufficient schedule. And you'll see that, for example, at paragraph 68 on page 26, where he says, I propose to deal with the breach of the unless order by failing to serve a
Sorry,
complete...
I'm behind you, where are you?
Sorry, 68, my lord, on 26, page 26, where he says, well, I don't need to look at the paragraph. We can look at the next subheading, failure to serve a complete and sufficient schedule. And the problem with that reasoning, as we've discussed, is that neither paragraph 4b of the order of the 3rd of July, nor paragraph 2 of the unless order of the 31st of July required the appellants to ensure the schedule was complete and sufficient. What those paragraphs required was that they should give the requisite instructions to Concilier, which they did, and serve the schedule that Concilier produced, which they did. And so the judge was led into error by case law about Part 18 responses. I'm going to take you, in light of my lord's submissions, very briefly to Gravity, in light of my lord's observations, very briefly to Gravity Highway and a few of the other authorities mentioned in the skeleton argument. But I should start, and I've now caught up with my Lord Justice Newey, by saying that none of the prior authorities is really on point, because none of them involves the interpretation of any order with the same wording as a relevant order in the present case. Each authority is simply a decision on the interpretation of the wording of the order that had been made in each case, and the wordings of the orders in the previous cases are different from the wording of the order with which we are concerned. So those decisions are really of very limited, if any, utility or relevance in the context of this appeal. Gravity Highway is in the authorities bundle at tab 27. If my lord's using electronic bundles, it's page 419. And there are two relevant orders in that case, and my lord will find them both on page 422 using the pagination in the bottom right-hand corner. Page 343 of the report. The first relevant order is towards the end of paragraph 7. It's the first highlighted section on the page at B. The claimants are to respond to the defendant's questions or requests under paragraph 4 above by completing an additional column in the same document marked GM response to MM queries above. And then the second order is in paragraph 11, which is the second highlighted section on the page. It's paragraph 4.1 of the order of the 16th of December 2019. In that case, in the event of a failure to comply with paragraph 5 of the order, the claimant's claims under item 1 of the particulars of claim B struck out. And then we can turn 2 pages on to page 424 of the bundle, page 345 of the report. In paragraph 27, Mr. Justice Butcher cites some cases about failures to comply with unless orders for the provision of further information, including a case called QPS. And there's a quote on the next page from the decision of Lord Justice Simon Brown in that case. And my lords will see the words complete and sufficient in the 4th line of the quote on page 346 of the report, 45 of the authorities bundle, between B and C, where I think that's the fons et origo of complete and sufficient in the decision of Lord Justice Simon Brown. And then at the beginning of the second paragraph of the same quote from Lord Justice Simon Brown, I would regard an unless order as breached whenever a reply is plainly incomplete or insufficient. But I think the key point from QPS is actually to be found in the decision of Lord Justice Walker, which Mr. Justice Butcher quoted in paragraph 29. It's not been highlighted, but the key bit is starts just between E and F, where Lord Justice Waller said, it is clear that where an order for particulars is made, it is in breach of that order to respond not entitled, or to give an answer which suggests that the matter is already sufficiently pleaded, or which does not deal in any way with the request. So if you're ordered to provide further information, you've got to provide further information. If you don't provide it, you're in breach. And then Mr. Justice Butcher summarises the case law on Part 18 requests on the next page, 425 of the authorities bundle, 347 of the report, paragraph 33, where he sets out some propositions, and one is what we have seen already. My lords know what I emphasise: in assessing whether or not there's been compliance with an unless order for the provision of further information, the court will consider whether the information is plainly incomplete or insufficient, given the terms of the order as to the information to be provided. And that's clearly about assessing whether there has been compliance with an unless order for the provision of further information. The test set out is applicable by its own terms only to such orders, because where the court has made an order for the provision of further information, asking the question whether the information that has been provided is complete and sufficient given the terms of the order as to the information to be provided, is simply another, perhaps unnecessarily long-winded way of asking whether the order has been complied with or not.
Well, you get that from paragraph 34.
Yes. If,
The order was the claimant should provide responses. It didn't specify any degree of detail.
exactly.
And they did respond.
Exactly. But the order in the present case did not require the appellants to provide information under Part 18. As my lords have seen, it required them to give instructions to Concilio, which they did, and serve the schedule produced by Concilio, which they did. Gravity Highway has no relevance. The test in Gravity Highway is simply not applicable because we're not concerned with the type of order to which that test applies. We say potentially more helpful guidance can be found in the authorities that we have referred to, not for some sort of universally applicable rule that should be slavishly followed irrespective of the wording of the order, but simply to highlight that the correct approach is to look at the wording, construe it, look at the facts relating to compliance and non-compliance, and decide whether what's required by the order has been.
As I said before, what have you been ordered to do, and have you done it?
Precisely. And so we refer to, I'll deal with this very briefly, Real Credit Denmark, at tab 5 of the authorities bundle. It's a decision of Lord Justice Tuckey with whom Lord Justice Morritt agreed. And the order that had been made in that case is at the bottom of page 61 of the authorities bundle. Unless, the final two lines, unless the plaintiffs serve a list of documents setting out in proper form all relevant documents that have been in their possession, custody, or power. So on a fairly superficial level, there's some comparison to be made with the present case in that the plaintiffs are required to serve a list of documents. But then there's that extra wording about the list needing to set out in proper form all relevant documents that are or have been in their possession, custody, or power. That's obviously not wording that features in any of the orders in the present case. And it might be thought that the requirement in Real Credit for the list to contain all relevant documents is a requirement for completeness. And it might be said that if there were some documents in the possession, custody, or power of the plaintiffs in that case which were not on the list, then the list did not contain all relevant documents and the plaintiffs were in breach. And that's certainly the assumption on which the defendants proceeded in that case, as we can see in page 62 of the bundle, where in the middle of page 4, second highlighted passage, my lords will see on 2nd of March, the lender served a list of documents which was in the proper form. It was 186 pages long, listed over 2,500 documents. It was met within days by an attack from the valuer solicitors to the effect there appeared to be very large gaps in the list, that some documents were obviously missing. And the judge at first instance, Mr. Justice Buckley, was persuaded by the defendant's arguments. We can pick up everything we need from the quote at the top of page 65 of the authorities bundle, where the judge at first instance said, I reached a conclusion the discovery is still woefully inadequate. There's no evidence in the affidavits that satisfies me it's been undertaken in a proper or careful fashion. Large gaps do still remain. And Lord Justice Tuckey adds he therefore found there had been a failure to comply with the unless order. But Lord Justice Tuckey took a different approach. He rejected the argument that the list had to be complete. He considered some case law, including Rice and Wolfe, and at the bottom of 67, he considered the rules as they stood at the time in respect of discovery and lists of documents. And then the core of his reasoning is on page 68, internal page 10. We're starting with the penultimate paragraph, second sentence. The unless order required service of a list containing more than 2,500 documents was served. It was not suggested to the judge this list was served otherwise than in good faith. And then the next paragraph, applying the language of Rice and Wolf, I think the lender's list could fairly be described as a list. It was not illusory. It would still be a list, even if a subsequent application for specific discovery had elicited further documents. So I think the judge was persuaded to adopt the wrong approach and applied the wrong test. So Lord Justice Tuckey there is rejecting the suggestion that the order in that case required the list to be complete. He effectively holds that it would have still been a list in compliance with the order if it had been incomplete, even, as he says, even if a subsequent application for specific discovery had elicited further documents. Now, as I say, of course, that's not precisely on point given the differences in the wording of the orders, but it's helpful, I suppose, insofar as Lord Justice Tuckey rejects the contention that the order required the list to be complete. It shows there's no universal requirement for a list or schedule served in compliance with an order to be complete and sufficient. And it shows that what was said in QPS and Gravity Highway is not some invariable rule of law which applies irrespective of the wording of the order in question. Ultimately, as my Lord Justice Lewison has said, it will depend on the wording of the order in question, which must be construed in the normal way, taking account of any applicable factual matrix to determine what the party in question was required to do. The only other case to look at is Atrium at tab 17 of the authorities bundle. And again, I take my lords to this not for some sort of invariable rule, but simply as an illustration of what we say is the correct approach. The order is in paragraph 14, which my lords will find on page 261 of the authorities bundle at the bottom of the page, paragraph 14, and the key bit is actually in subparagraph 2 at the top of the next page. In the atrium proceedings, the liquidators shall by 4 p.m. on 28th of June, and then Roman 1, conduct a search for documents falling within CPR 31.6 in compliance with the requirements set out in CPR 31.7. And my Lord Justice Lewison set out CPR 31.7 towards the bottom of the same page, paragraph 18. It's the requirement to conduct a reasonable search. So in other words, the unless order in that case said that the liquidator's claim would be struck out unless they conducted a reasonable search. And then on page 267, my Lord Justice Lewison referred to the guidance about reasonableness of searches in CPR 31.72. That's paragraph 36. Where's that? That's on page 267, yes, 36. So my Lord has said, well, it requires a reasonable search. Reasonable search is essentially defined or described by CPR 31.72. And then my Lord applied those factors in paragraph 37 and concluded at the end of 38 that, in my judgment, he made no search for these critical documents, let alone a reasonable search. So what my Lord has done there is to construe the order, hold that it requires a reasonable search, look at the facts, hold that the liquidators didn't make any search for the critical documents, let alone a reasonable search, so they're therefore in breach. And that, we say, is simply another example of construing the relevant order to see what it requires and then asking whether it has been complied with. That's the approach the judge should have followed in the present case. He should have looked at paragraph 4b of the order of the 3rd of July to see what it required, and he should have held that the appellants complied with it. I've got 4 further points on the judge's approach. The first one is that his reasoning gives rise to internal inconsistency in the judgment, because in respect of the paragraph 3 instructions, he holds that the appellants are not in breach because they gave the relevant instructions to concilio. And in respect to the report, he holds that the appellants are not in breach because they gave the relevant instructions to concilio and served the report that concilio produced. In respect of the schedule, he should have adopted the very same reasoning. The fact that such different reasoning was adopted instead in respect to the schedule is not consistent with his reasoning elsewhere in the judgment regarding the instructions and the report. Secondly, the judge's approach regarding the schedule is contrary to the strict interpretation that he professed to be adopting. If my lords could turn back to the core bundle, the judgment at tab 3, on page 17, paragraph 27, my lords will see paragraph 27, page 17, the judge refers to CPR 40.1.2. There is no such civil procedure rule, to be clear. The judge is referring to paragraph 40.1.2 of the White Book, but his summary in B is accurate. It's what the White Book notes say: orders which contain penal consequences, the judge adds, such as unless orders, the unless order in this case, should be interpreted strictly. And the judge followed that approach when it came to the instructions in paragraph 35 of his judgment, and also in respect to the report in paragraph 1661. But he departed from that approach when it came to the schedule, because he ended up imposing a brand new requirement for the appellants to ensure that the schedule was complete and sufficient, which was not set out expressly in any order. My lords, that's just the unpermissible creation ex post facto of a trap. Thirdly, the error in the judge's approach is clear from the fact that completeness is an extremely high bar. Of course, on the judge's approach, if it becomes plain, it's a word he used, a few months later, that the schedule has failed to mention a single item which it ought to have included, then the schedule is plainly incomplete. It's plain that it's incomplete. There's been a breach of the unless order. The fact that the judge's reasoning gives rise to such a high bar means it cannot be correct. Fourthly, whilst cautioning your lordships not to adopt any requirement for completeness and sufficiency, save, of course, where it's spelt out in the terms of the relevant order, we say that if there is any requirement for completeness and sufficiency, then it should apply not to the schedule, but to the instructions which the order required the appellants to give to concilio. And as the judge held, the instructions were complete and sufficient in respect of the paragraph 3 tasks. They were complete and sufficient in respect to the report, and we'd say they were also complete and sufficient in respect to the schedule because they complied precisely with the requirements of the order. They said absolutely everything that the order required them to say. The question is whether the appellants complied with the unless order. So the key task is to identify what the unless order required them to do. If, as I say, I urge your lordships not to go down this route, but if your lordships were to adopt a requirement of completeness and sufficiency to anything, it can only be attached to those things that the appellants were required to do, and whether it was complete or sufficient or not can only be judged by reference to the terms of the order. Did they do what the order required them to do? And as I said, they gave the instructions, and the instructions said exactly what the order required them to say. So that's where we say the judge went wrong on the first topic. Before I turn to the second topic, relief from sanction, I need to deal briefly with the scope of the imaging obligation and whether it extended to Mr. Skinner and Mr. Cohen. And I've covered most of the points on which we rely already in the course of my submissions on the background.
Sorry, just hold on a minute. The judge, in looking at relief against sanctions, is looking at two breaches. Look at para 62. The first is the failure to serve the schedule by 4 p.m. as required by paragraph 2. And the second is the late service, 22 minutes, or you can forget the second because
Yes.
he gives relief. But if you're right so far, there is no breach, therefore no sanction.
Yes.
So when you are coming on to look at sanction, what is the assumption that you are making?
It's on a contingent basis.
That
And
the
the
judge was right,
pessimistic assumption, yes.
yeah, right to say that your clients were required to serve a complete schedule.
Yes.
Is that's the assumption?
Yes, and I'm going to deal with it briefly. I'm afraid that there isn't a shortcut of saying, well, let's just decide the breach point and only come on to relief from sanction if we need to, because the arguments on relief from sanction overlap with the arguments on strikeouts.
Yes, I follow.
So I'm not going to spend as long as I have on the breach point, but I'm going to cover it. But before I get to that, I need to deal with the scope imaging obligation and whether it extended to Mr. Skinner and Mr. Cohen. I've covered most of the points already. The judge identified the scope of the debate in paragraph 36 of his judgment at page 20 of the core bundle. Page 20, paragraph 36, where he says, although not directly relevant to the question of whether defendants breach unless order thereby triggering the sanction, it's convenient to deal now with the question of which online storage accounts concilio is supposed to be given effective access to under the 3rd July order. The defendants say it was only 2 accounts, Sam at taylorgrange.com and Sam at futurehighstreetliving.com. Those are both online storage accounts of the third defendant, Mr. Ginder, but the defendants accept not limited in the latter case to 31st of January 2023. The second claimant says that in addition to those accounts, concilio were also meant to be given access to Steve Skinner, taylorgrange.com, Peter Cohen at taylorgrange.com, and Simon Murray Twin at taylorgrange.com. And the judge held that the imaging requirement in paragraph 2 included Mr. Skinner and Cohen, but not Mr. Murray Twin. And the judge's reasoning on this point is in paragraphs 41 and 42 on page 21 of the core bundle. He accepts in paragraph 41 that the genesis of the order related to the concerns about Mr. Ginder's deletion practices. And then he says in line 5, middle of the line, however, the 3rd of July order, setting out the exercise to be undertaken by concilio, was not restricted on reporting on deleted and modified documents and recovering them where possible. It also covered disclosure of documents which had not been deleted or modified. So the disclosure obligations in relation to all custodians named in the DRD could be completed. My lords, that's simply an assertion. There is absolutely nothing in the wording of the order of the 3rd of July or the factual matrix to support that conclusion. And then in the final 4 lines of paragraph 41, the judge says the 3rd of July order gives no indication that the online storage accounts for the purpose of recovering deleted documents, target documents, would be any different from the online storage accounts for the purpose of bringing disclosure up to date, further documents. So what he seems to be saying is that if the disclosure exercise of further documents was not limited to Mr. Ginder, then the recovery of deletions exercise, the target documents, was also not limited to Mr. Ginder. But it's all very muddled. It's circular. The judge starts by assuming that which he seeks to prove. The definitions of further documents and target documents really don't shed any light on this issue at all. And then paragraph 42, I am not satisfied, however, that the online storage accounts to be processed by concilio under the 3rd of July order included Mr. Murray Twin. He goes on to say, whilst he accepts the logic, there's no reason why disclosure should not be brought up to date for Mr. Murray Twin's email account. Nonetheless, the DRD, which the online storage account are defined by reference to, did not include Mr. Murray Twin's email account. And, my lords, the judge misses the significance of the omission of Mr. Murray Twin. If the imaging obligation had been intended to cover all custodians, then the order would have referred expressly to Mr. Murray Twin, who'd been added as a custodian after the DRD. The fact that the order did not refer expressly to Mr. Murray Twin is therefore a very strong indication that it was not intended to cover all custodians. So the judge's conclusion on this point we say is ultimately highly unsatisfactory and wrong for the reasons I've developed. There are two further points to confirm that the judge got it wrong. The first is if the imaging requirement was meant to cover all custodians named in the DRD, to pick up the judge's wording that we've seen in paragraph 41, why stop at Mr. Skinner and Mr. Cohen? As you've seen, the DRD sets out 8 custodians in total. Why not the rest of them? The reality, of course, is that the imaging requirement had nothing to do with Mr. Skinner or Mr. Cohen or indeed any of the other custodians. It was driven by what had been said about Mr. Ginder's deletion practices, and it was limited to Mr. Ginder's devices and online storage accounts. Secondly, why on earth should Mr. Cohen be included? As my lord saw in the disclosure certificate, he was removed as a custodian at some point before the 11th of January 2023, a year and a half before the order of the 3rd of July 2024. Why on earth should the imaging requirement, driven by concern about Mr. Ginder's practice of deletions, extend to someone who had long since ceased to be a custodian at all? So then, my lords, I can turn to the topic of relief from...
Just before you do, I'm not sure that this adds anything to what you're saying, but if you go back to paragraph 37 of the judgment, the judge says the online storage accounts, which paragraph 2 of the 3rd of July order requires the defendants to give access to. Now, I think when you were reading out paragraph 2 of that order, you read it out on the basis that it all applied to Mr. Ginder.
Yes.
Not the defendants.
Let me just go back to it.
Yeah, the third defendant.
I think that's what it. I think that's what it says. I'm sorry if I misspoke.
No. I think you. Well, no, I think on your case you spoke correctly. The question is, was the judge justified in saying that paragraph 2 requires the defendants
No,
to give access?
no, that's not what it says. Plainly, not what it says. I've brought it up. The third defendant is the only defendant mentioned there.
Now, what does this issue go to? Strikeout?
It's convenient, as the judge said, to deal with it when we're construing the orders, but it goes to relief and strikeout on our case. On the other side's case, it also goes to breach.
Right.
So I think the judge is right to say that it's convenient to deal with it when you're construing the orders because it's part of the terms of the orders, but it fits into the argument at various different places. So we come on to relief from sanction, and as my Lord Justice Lewison said, if your lordships are to hold there's no breach of the unless orders, then the second topic simply doesn't arise at all. It arises only if you hold that there was a breach, and we can pick this up back in the core bundle in the judge's judgment at page 24 of the core bundle with the heading right at the bottom of 24. It's the last thing on the page, relief from the sanction. And then over the page, the judge sets out the principles, including the provisions of CPR 3.9, and then paragraph 64, there's the 3-stage test from Denton and White, seriousness and significance of default, whether there's a good reason, all the circumstances. And then paragraph 65, dealing with seriousness and significance of the default, the judge sets out the common ground in A, which I emphasise. I can and should take into account the underlying breach which led to the unless order being made, but I should not at this first stage take into account any other breaches or any other conduct of defendants in deciding on the seriousness and significance of the breach. That was common ground. My lords, the judge failed to apply that principle because he did not limit his consideration of the serious and significance of the breach to the breach of the unless order. He took account of other criticisms of the appellant's conduct which were not breaches of the unless order. Now, they might have been breaches of orders, but crucially, they were not breaches of unless orders. So they were not matters to be taken into account in stage 1 of the analysis. And that is clear from the judge's reasoning. We can start from page 26 of the bundle with the heading, failure to serve a complete and sufficient schedule. And that's what the judge held to be a breach of the unless order. But then when we come to the next page, page 27, paragraph 72, although the judge starts, I'm satisfied that the failure to serve a complete and sufficient schedule is both serious and significant for the following reasons. The reasons that follow are all to do with breaches of other orders to which no unless terms were ever attached. So you can see in A, although the failure to produce a complete and sufficient schedule was caused by Conciliar not imaging the correct online storage accounts, I nonetheless consider that that failure formed part of the defaults, plural, by the defendants. So he's already widened it to defaults, plural. Those defaults, plural, have meant that none of the outputs of which the 3rd of July order was meant to achieve in terms of disclosure of deleted documents, further disclosure or details of deleted documents have been achieved, and they should have been achieved a long time ago. Well, of course, he's already gone wrong because the judge has held that not imaging the correct online storage accounts is a breach of paragraph 2 to which the court never attached unless terms. And his comments about outputs in terms of disclosure are a reference to paragraph 6 of the order of the 3rd of July. But the court never attached unless terms to paragraph 6 of the order of the 3rd of July either. A breach of paragraph 2 and or paragraph 6 was not a breach of any unless order and was not something the judge should have taken into account in stage 1.
Is that right? I mean, we're proceeding on the assumption that the judge was correct to say that the failure to serve a complete schedule was a breach of the unless order.
Yes, that has to be the hypothetical basis
So
of the discussion.
if that is correct as a matter of interpretation of the order, then why is the judge incorrect to say that because the schedule was not complete, it is a serious breach because what the schedule was designed to produce was a complete list of the documents that needed to be disclosed?
Well, no, because even then it's wrong, because as my lord saw, the schedule is to identify any documents deleted after the service of the injunction of His Honour Judge Worcester on Mr. Ginder. That's its primary purpose. It's about policing the injunction. That's got nothing to do with disclosure, witness statements, preparation for trial, whether there might be committal proceedings in respect of a breach of an injunction is a separate matter. The judge rolled it all up, and potentially this was, obviously I wasn't there at first instance, but there had been an application for extensions of various deadlines, including deadlines to which unless orders had not been attached. And the judge seems to have taken account of those submissions in the relief from sanction analysis stage 1, but they really are separate matters that ought to form no part of the stage 1 analysis. He should have been asking whether the, on his reasoning, incompleteness of the schedule was serious and significant. And we say that the error is apparent from the repeated references in paragraph 72 to matters to which no unless terms had ever been attached, even on the judge's approach. B, even if, as Mr. Atkins suggests, the updated redacted schedule could be served by 4 p.m. on 6th of September 2024, and disclosure completed by 4 p.m. on the 11th of September 2024. Well, completion of disclosure has got nothing to do with it unless terms weren't attached to that. And the judge carries on saying these dates are long after the dates on which the 3rd of July order and subsequent unless orders required the schedule to be served and disclosure completed. The consequence of that date for exchange of witness statements has been put back considerably, and the dates of other directions have already been pushed back. Preparations of the parties for the trial he refers to. So if the service of an incomplete schedule was a breach, then the judge should have dealt with the seriousness and significance of that breach. Instead, he's widened out the inquiry to consider missing deadlines about disclosure, witness statements, other directions, but the schedule wasn't to do with preparations for trial. So
So to be absolutely clear, going back to the requirement for the schedule, that is to give names of documents deleted or modified following service of Judge Worcester's order.
yes, and so
It's as limited as that.
and everything that follows is a subset of item 1. That's the purpose of the schedule, and obviously one can see why it's in there, because the other side were disappointed that they hadn't got the imaging order. The order of His Honour Judge Worcester requiring Mr. Ginder not to delete documents is, on the other side's approach, rather unsatisfactory for them, because they don't know whether he's complied with it or not. The schedule is about policing the order of His Honour Judge Worcester to see.
So, Judge Worcester's order was made on the 18th of June, so we're only concerned with things that have happened since the 18th of June.
Yes, and one of the, we don't need to get into this, but one of the problems that arose in practice is that Concilio discovered that the date of deletion of documents is not immediately apparent, and so they had to include in the schedule lots of documents which might or might not have been deleted after the service of His Honour Judge Worcester's order.
You get this from paragraph 4b of the 3rd of July order.
Yes,
File name of any document deleted or modified following service of Judge Worcester's order.
yes, and everything that follows is a subset of, or further information about item 1. So we say that the judge is making a mistake of focusing not on the seriousness or significance of the breach, but on the seriousness or significance of other things that have no relevance in the stage 1 analysis. If we go back to paragraph 72, it's the same in D, E, F. F, for example, right at the end, there's a reference to completion of disclosure. It's got nothing to do with this. And then G, the Court of Appeal in Denton said that the question of whether the breach imperils future hearing dates or disrupts conduct of litigation is often a useful measure of whether the breach is serious or significant. Conduct of this litigation has been significantly disrupted. Well, maybe, but not by the provision of an incomplete schedule, by the failure to image, which had no unless terms attached to it, the failure to complete the disclosure exercise, which had no unless terms attached to it. So we say the judge's approach was wholly misconceived. I won't turn it up, but for reference, paragraph 38.1 of our skeleton argument, we say, in considering the seriousness and significance of the breach, the judge had in mind the wrong order, and that's CB 340 for the transcript, and then CB 341, we say the judge's points about the number of documents requiring manual review, the defendant's ability to give disclosure within the time they had proposed and so on, were all irrelevant to the questions he was dealing with. He muddled the defendant's obligation to serve the schedule with their obligation to serve a list for disclosure on the substantive issues. And then paragraph 38.2, we say it's unclear how the judge got into this muddle, but it meant that his approach to the second relief application was fundamentally flawed. Now, my learned friend's response is to say that the judge was right to conflate the breaches of orders to which unless terms were attached with breaches of orders to which no unless terms were attached. And just to give your lordships a reference, that's paragraph 41 of their skeleton argument in the core bundle at page 372. What my learned friends say is incorrect. My learned friend's submissions are contrary to the common ground which the judge recorded in paragraph 65, that the court should not, in stage 1 of the Denton analysis, take into account any other breaches or any other conduct of the defendants. Then we move on to the second stage of the relief from sanction analysis, good reason. The judge holds that there is no good reason because the problems regarding the imaging process, he says, are due to the inadequacy of the instructions which Ms. Williams gave to Concilio. And he therefore says that Ms. Williams, the defendant's solicitor, was therefore at fault for the problems that arose. And my lords will see that in the core bundle at page 29. In best place to get it from is Roman 3. The written instruction to Concilio simply attaches a copy of the 3rd of July order and repeats some of its terms. It did not actually identify which online storage accounts were to be imaged by Concilio. And the definition of online storage accounts in the 3rd of July order refers to section 2 of the DRD and Sam at futurehighstreetliving.com, but it does not otherwise identify the online accounts to be imaged. And then 5, Roman 5, in those circumstances, providing Concilier with a copy of the 3rd July order and repeating some of its terms in the instructions to Concilier was a totally inadequate means of informing Concilier which online storage accounts it was to image and interrogate. And then Roman 6, Ms. Williams, having failed to ensure Concilier were given clear instructions as to which online storage accounts they were to image, etc. So we say, first, again, the judge is focusing on the wrong breach because he's talking about the imaging obligation to which no unless terms are ever attached. Breach of that imaging obligation didn't give rise to any sanction from which relief might be required. But secondly, what the judge said on this point is completely unfair to Ms. Williams. The judge has already held that she gave the instructions required by paragraph 3 of the order of the 3rd of July. Those instructions complied accurately with the order. And as my lords have seen the instructions, they also said everything that the order required them to say under paragraph 2. If those instructions were inadequate, it wasn't her fault. It was the result of a lack of clarity in the order of the 3rd of July, which didn't specify which accounts were to be imaged, didn't specify the date range. If the process has gone wrong because the court's own order was insufficiently clear, that's obviously a good reason.
And is it of any significance that the other side approved the instructions?
I was yes, my lord, absolutely going to come on to that, but I was just going to, for your lordship's note, refer your lordship to what we say in paragraph 39.4 of our skeleton argument, core bundle 344. The judge ought to have concluded the breach was caused by a lack of clarity in the 3rd of July order and not by Ms. Williams' instructions which reflected it. This was a good reason for the breach, and the judge ought to have found it was so. And also paragraph 22C of the grounds of appeal, we say the judge should have found the instructions were inadequate because they mirrored the 3rd of July order, and it was not clear on the face of the 3rd of July order which email accounts had to be imaged. The judge ought to, therefore, to have concluded that the breach was caused by the lack of clarity in his own order and not the instructions which mirrored it. If he had concluded that, he would have found that was a good reason. And then we make my Lord Justice Newey's point that the other side had an opportunity to review the instructions in draft. They did review them and provide comments. They didn't raise any issues or concerns about the clarity of the draft instructions. So it's wholly unfair, we say, to blame Ms. Williams. And then on stage 3, all the circumstances, the judge's reasoning was critically dependent on his conclusion that the 3rd of July order required the imaging of the accounts of Mr. Skinner and Mr. Cohen. And my lords will see that at page 33 of the core bundle, 83, where he refers to email accounts of Steve Skinner and Peter Cohen. 84. He also refers to that finding. And 85, he says there's no application to vary the 3rd of July order. Do not consider it right in principle to vary what I found to be the requirement that the email accounts of Steve Skinner and Peter Cohen should be imaged. So that's all wrong for the reasons you've heard. My lords, I propose to address the remainder of what the judge says about the 3rd stage of the relief from sanction analysis, all the circumstances, in the context of the next topic of strikeout, which is what I'm going to turn to now. And I have to raise with your lordships at the outset a point that has been puzzling me on the topic of strikeout. It's, I think, a preliminary point. And I'm not sure, I have to say, for my part, that strikeout is really part of this appeal at all. And that's because the judge didn't strike out the defence. He held that the defence had already been struck out and he refused to grant relief from sanction, but he didn't strike out the defence, and he dealt with the topic of strikeout only in case it was relevant to the issue of costs. And my lords can see that from page 17 of the core bundle, tab 20, page 20, third time lucky, paragraph 24 of the judge's judgment, where he says, as to the second claimant's application, paragraph 24, as to the second claimant's application to strike out the defence of the defendant under CPR 3.4, strictly speaking, if I determine that the unless order has been breached, then I should not grant the defendant's relief from sanction. So the defendant's defences are struck out and they are barred from defending the claims. Then I do not need to decide this application. I will, however, decide the strikeout application in any event, because even if I determine that the defendant's defences are struck out and that they've been barred from defending the claims, because the sanction imposed by the unless order applies, deciding the strikeout application will still be relevant to the issue of costs. But given that the judge didn't strike out the defences, I have to say I'm struggling for my part to see how strikeout could really be a question of appeal. My clients can't appeal against the striking out of the defences because the judge didn't strike out the defences. He held that they'd already been struck out. So what the judge said about strikeout is, I think at best, something which the other side could rely on in a respondent's notice. They could have said, if the judge was wrong to hold that the defences had already been struck out, then he could and should have struck them out. So it's a respondent's notice point, if anything, it's different or additional reasons. But it's not a point that's been made by the other side in their respondent's notice, which my lord will find in the core bundle at tab, 21 of the core bundle. That's 354. And they only raised 4 points in the respondent's notice. The first is about a breach of the unless order. The second, paragraph 2, is premised on a breach of the unless order. That's clear from the first line. Paragraph 3 is also about breach of the unless order. And then paragraph 4 is about paragraph 98 of the judgment, which is part of the judge's reasoning on relief from sanction, the third part of the three-part test. There isn't any paragraph in the respondent's notice premised on there being no breach of the unless order. They don't say anywhere in this document, if there wasn't any breach of the unless order and the defences hadn't already been struck out, then the judge should have struck them out. So, as I say, I'm struggling for my part to see how it could be part of the appeal. It's not something for which we can appeal because it's not what happened. And if anything, it's a different or additional reason, but it's not in the respondent's notice. But I'm going to address your lordships on the topic.
I wonder if it is actually a respondent's notice point rather than a prosecutor. A respondent's notice is upholding the order made on different or additional grounds. If you wish to change the order, you are normally required to cross-appeal. So if you were to succeed on your appeal and the respondents wish, instead of the order dismissing your applications, to have an order striking out your defence, that would normally be a matter for a cross-appeal, for which permission would be required.
I think your lordship is right. I think that I think solves what I've been struggling with. It's not a respondent's notice point, is it? It's a cross-appeal.
Could I just mention one thing, not wishing to interrupt my lady friend at all, just because this point obviously comes somewhat from left field, given that it is a ground of appeal they have raised. So certainly the concept of a respondent's notice in those circumstances would have seemed bizarre. But in my submission, in any event, if one looks at the order, and again, I'm dealing with this.
Yeah, well, I was looking at the order, just trying to see what it was that the judge actually ordered.
Right.
Yes,
So it's in core bundle, page 4.
Yeah.
And you'll see at the bottom of page 4, this is in the recitals, that there is a definition, the 19th of August application. And
An order striking out.
yes.
Yeah. So that's yeah.
Right. So that the order striking out is embraced within the definition of the 19th of August application, and then we see at paragraph 2 that the 19th of August application is granted. And given that one appeals from orders, not from judgments, that's no doubt why my learned friend's legal team pursued an order
Yes, well,
against.
that may be right. So perhaps that is the answer.
That may be it. I raise it because it's a point that I've been struggling with. It would mean then that the order doesn't actually reflect the terms of the judgment containing the reasons for it, but there we are. I'm going to make my submissions on strikeout, but I did want to raise that point with your lordship. I felt duty bound to do so because I've been struggling. Obviously, I wasn't involved in drafting the grounds of appeal, but for my part, struggling to work out how it fits in. What the judge held in paragraphs 114 to 124 of the judgment was that if he had concluded that defences had not been struck out already, then he would have struck them out. And he started by explaining why he would focus on non-compliance with paragraph 2 of the order of the 3rd of July, and that's in the core bundle at page 42, paragraph 120, where he says that he's satisfied the second claimant solicitors intended to make and would have made an application in their application dated 23rd of July 2024 for an unless order in respect to paragraph 2 of the 3rd of July order. If the defendant solicitors had not sent them an email on the same day, erroneously stating that all devices and online storage accounts have been imaged.
Sorry, I've got lost. Where am I?
Sorry, my lord. Paragraph 42, sorry, page 42 of the core bundle, paragraph 120.
Yes.
The judge starts by explaining why he's going to focus on non-compliance with paragraph 2, the imaging obligation, in the strikeout analysis. And he says he's satisfied that the second claimant solicitors intended to make and would have made an application, in their application dated 24th of July 2024, for an unless order in respect to paragraph 2 of the 3rd of July order, if the defendant solicitors had not sent them an email on that same day, erroneously stating that all devices and online storage accounts had been imaged. My lords, what the judge said there was wrong. The email to which he referred is in the supplemental bundle at tab 33, page 245. Paragraph 2, the defendant solicitor, Ms. Williams, said the image of all devices have been taken. So she didn't state that all devices and online storage accounts had been imaged. There's no mention of online storage accounts. So the judge's description of that email is simply wrong. That might be how the other side understood it, but that's not what she said. But going back to the judgment, we were in the core bundle at page 42. And the judge's core point on the topic of strikeout was that the initial problems with the imaging process under paragraph 2 had meant that the further disclosure exercise required by paragraph 6 couldn't be complied with in time for the trial. And your lordships will see that in paragraph 121 at bottom of page 42 and over the page. The final 4 lines of that paragraph on page 43, I'm not satisfied that it could all be done again for the missing online storage account in time for trial, given the other directions that would need to be complied with, whether or not the exercise extends to the email accounts of Steve Skinner and Peter Cohen. And then paragraph 124 at B, I have found the disclosure exercise contemplated by the 3rd of July order could not now be completed in time for trial. C, it's not appropriate to vary the disclosure obligations of the defendants under the 3rd of July order so they could be completed in time for trial. D, even if I did vary the defendant's disclosure obligations or I was wrong and they only extended to Mr. Ginder's email account, I was not confident that even then the disclosure could be completed in time for the remaining directions to be carried out in time for trial. And, my lords, we say that the judge exercised his discretion on an incorrect basis and exceeded the generous ambit within which a reasonable disagreement is possible, and that the decision was therefore plainly wrong. Perverse in the sense of being a decision which no reasonable judge could have reached. In terms of the chronology, the hearing before the judge took place on the 2nd of September. The trial was due to start a month and a half later on the 14th of October. And as matters stood at the time of the hearing before the judge, the sam@futurehighstreetliving.com account had been imaged for the whole period. The keywords had been applied and the hits had been subject to manual review. And in addition, by the time of the hearing before the judge, the data in the sam@taylorgrange.com account had also been imaged. Now, as you've heard, there was initially a problem about locating the correct version of sam@taylorgrange.com during July, but it had been located and imaged in August, as described in Concilio's supplemental report. And following the image of that account, the keywords had been applied to the data, the agreed keywords, and that exercise resulted in 4,444 additional documents from sam@taylorgrange.com, as well as 77 additional documents from the OneDrive. So just over 4,500 additional documents. And you'll see that in the evidence in the supplemental bundle at tab 20 at page 158 of the supplemental bundle. Tab 20 is the 7th witness statement of Ms. Williams. And in paragraph 14, she explains that she believed that the pool of documents for review from the sam@taylorgrange.com would be very minimal. And then she says, second line of paragraph 14, it has since transpired that there are 4,444 documents from the sam@taylorgrange account and 77 from the OneDrive. The search terms are very broad, and of the documents we've reviewed to date, a huge number of documents are not relevant to this litigation or are privileged. To date, 8,736 documents have been reviewed, namely 614 have been marked for disclosure, with 277 marked for final review. So the search terms are throwing up a huge number of
Could
false...
you just explain the numbers? He says there are 4,400 documents from one source, 77 from the other, but she says that 8,700 and something have been reviewed. So what else is she talking about?
The other devices, but in the interests of ensuring that that they didn't fall down again, they imaged all the accounts that Concilio found, including Mr. Skinner, Mr. Cohen, and others. There was a very significant number of custodians who were imaged.
Right. Where does this 8,700 come from?
That's when you include the other custodians who
Is it?
we say, well, she says from the other devices. That's certainly my understanding, but the key point is that she's explained there are 4,444 documents from the sam@taylorgrange and 77 from the OneDrive. And then she says in 15 that the subject headings of the 4,444 emails have been reviewed with a view to filtering down the volume of documents. And she provides a schedule of the direct hits from sam@taylorgrange.com M365 with highlights and analysis. And she says those highlighted in red are likely to be a relevant privilege or inter partes document. She explains, I'm instructed that the following projects are not relevant to the square, and thus the emails which are related to the following projects are not likely to be relevant to the dispute. And so the point she's making is that Mr. Ginder had worked on lots of different projects over the years. This dispute was in relation to only one of them, the square. And if you looked at his emails, in particular the subject headings, you could see immediately that there were whole email chains relating to different projects, which might contain keywords because the keywords are incredibly broad, but which could obviously be excluded immediately on the basis of the subject heading and therefore removed from the process of manual review. And after the lengthy list, at the top of page 160, paragraph 16, she says, if we are permitted to filter out these documents, then the pool of documents for review would be reduced down to circa 2,228. My team will review these as soon as possible. I am confident we'll be in a position to give disclosure by 4 p.m. on the 11th of September 2024. And I have to say that 2,228 documents is, as anybody who's been involved in heavy litigation will know, an extremely manageable number of additional documents. From painful personal experience in 2023, for 5 months, I had to look at an average of 5,000 documents a day. I certainly, for my part, wouldn't have any fear of 2,228. It was clearly going to be possible to review that number of additional documents without derailing the proceedings. And what Ms. Williams was suggesting was entirely in line with paragraph 7 of the order of the 3rd of July, which required the parties to agree reasonable refinements to the searches so as to limit the requirement for manual review so far as reasonably practicable. So what she was suggesting was positively mandated by paragraph 7 of the order of the 3rd of July. And what happened back in July with the inability to find the sam@taylorgrange.com account was obviously unfortunate, and it gave rise to some delay. But by the time of the hearing before the judge, it had been found, it had been imaged, it had been searched, and Ms. Williams had made sensible proposals to speed up the review process in accordance with paragraph 7 of the order of the 3rd of July. And in those circumstances, we say it was plainly wrong and wholly disproportionate for the judge to say that he would have struck out the defences even if they had not been struck out already. And I rely in that regard on 7 points. First, strikeout should normally be a remedy of last resort. And of course, there may well be exceptional cases where a party has behaved so egregiously and unforgivably that immediate strikeout of a claim or a defence or perhaps an application is the only proportionate response, but that will be very rare. In most cases of procedural non-compliance, strikeout should be the last resort. Here, no unless terms have been imposed previously in respect of the further disclosure exercise. The judge jumped straight to strikeout without considering other options. That's a very serious step to take. The question is whether the facts as they stood at the time of the hearing meant that it was a proportionate one. Second point is, this is not a case of a defendant who has failed to give any disclosure at all. The appellants had conducted a search with the aid of Concilio back in 2022 and had given disclosure by the deadline. You've seen the disclosure certificate. They then gave supplemental disclosure on the 30th of January 2023 of the documents from Mr. Murray Twin, which contained the additional emails. This was not a case of complete, continuing recalcitrant failure to give any disclosure at all. The third point is that the problem which had arisen in July 2024 in respect of the imaging was inadvertent. My lords have seen the expert evidence of Concilio about the failure to locate the right M365 tenant. They found what they thought was the right account, but it was empty of data. It was inadvertent, and that would in itself constitute a good reason in terms of the 3-stage relief from sanction analysis, to which regard can be had in the strikeout context. But the fact that the problem had been caused, at least in part, by the inadequate wording of the court's own order is also a significant factor. The order, as my lords have seen, didn't clearly identify the relevant accounts or the applicable date range, and it was wrong for the judge to blame Ms. Williams, particularly in circumstances where the other side had had an opportunity to comment on the instructions and hadn't had any concerns about any lack of clarity. Fourth, the problem was not as significant as the judge believed it to be, because the further disclosure exercise did not extend to Mr. Skinner or Mr. Cohen. It was limited to Mr. Ginder's devices and online accounts. Fifth, this was not a case of a litigant setting its face against the court's requirements and intransigently refusing to comply. To the contrary, as my lords have seen, the appellants were trying to comply with their obligations in respect of further disclosure. The relevant accounts had both been imaged by Concilier by the time of the hearing. The keyword searches had been applied to both accounts using the search terms. So that there had been a problem, but the data had been located and imaged, and the further disclosure process was underway. An immediate strikeout sanction was plainly disproportionate in the circumstances. Six, it's clear from the evidence that the further disclosure exercise could have been completed in time for trial. My lords have seen both the evidence relating to the number of documents, which, frankly, whether it's 4,000 odd or 8,000 odd, it's still within the realms of the wholly manageable.
But you'll have to deal with the judge's rejection of that at para 101 of his judgment. He said he wasn't satisfied it could be done, and he comes back to that in para 104 E.
Yes. Well, that's completely wrong. My lords can see from the fact that there are, on any view, whether it's the 4,000 or the 8,000 or the 2,000, it's less than 10,000 documents. That is, in the context of heavy litigation, a piece of cake. That is not something that is going to require a long time. The judge's assessment is plainly wrong. As anybody who's been involved in that sort of heavy litigation would know, it's not the sort of thing
the judge himself has.
Well, no doubt, but perhaps a very considerable period since he was involved in a disclosure review exercise. In this day and age with electronic documents, that hosted on electronic platforms, that sort of number is, as I say, really no obstacle, particularly given that Ms. Williams had made sensible proposals to reduce the volume that would be subject to manual review to 2,228 documents. And that process of revising the search terms was expressly contemplated and, more importantly, expressly required by paragraph 7 of the order of the 3rd of July. But the judge set his face against it. He wrongly characterised it as an attempt to vary that order. That's paragraphs 85 and 125C of the judgment, when in fact the process of revision and reduction was mandated by the order. It wasn't a question of varying it, it was a question of implementing it. The judge said that on the appellant's proposed approach, there would only be 2 clear business days between the completion of the further disclosure and the deadline for witness statements, which he said was insufficient. And I'll give my lords the references to that. It's paragraphs 77G Roman 4, 102 and 124D. So he said
77G Roman 4,
102 and 124D, where he said that 2 clear business days between completion of further disclosure and the deadline for witness statements was insufficient. My lords, that's grossly unfair, because the judge's own order of the 3rd of July provided for there to be only 2 clear business days between the completion of the further disclosure and the deadline for witness statements. And I'll show my lords that briefly in the supplemental bundle at page 17. We start in 6G, about halfway down the page.
Sorry, I'm behind you. Which page?
I'm sorry, my lord. Page 17
17.
of the supplemental bundle.
This is the 3rd of July.
That's correct. And 6G, just before 7, the defendants have to produce to the claimant any disclosure documents identified from the searches by 4 p.m. on the 16th of August. That's a Friday. And then paragraph 18 on page 20, towards the bottom of the page, the date for the parties to comply with paragraph 8 of the order of District Judge Phillips, dated 22nd of February 2023, should be extended to 4 p.m. on the 21st of August. That's the following Wednesday.
I'm sorry, which paragraph?
18.
18.
So we've seen
Yes.
disclosure deadline was the Friday. 18, completion of compliance with paragraph 8 of the order of District Judge Phillips is the following Wednesday, so only 2 business days later. And the punchline is the paragraph 8 of the order of District Judge Phillips is at page 8 of the core bundle. No, supplemental bundle. Let me check. Supplemental bundle. It's the deadline for witness service of witness statements of fact. So the judge's own order provided for only 2 clear business days between the completion of the disclosure exercise and or further disclosure exercise and the deadline for witness statements. It was grossly unfair, we say, for him to say that the appellant's proposed timetable was insufficient when it precisely replicated what the judge himself had ordered. And the 7th point is that if and to the extent that time was tight, the judge was wrong to treat the appellants as being solely to blame for the fact that time was tight. Yes, of course, a month had been lost with the delay in finding the Sam at TaylorGrange.com data, but that was only a month compared with the very lengthy delays caused by the other side. As you've heard, Shakespeare Martineau delayed for 6 months before responding to Jury O'Shea's letter of the 10th of July 2023, and then they delayed for a further 5 months before making their ex parte application to His Honour Judge Worcester. If a litigant thinks that there is a serious issue relating to his opponent's deleted documents, then it's essential for him to raise that promptly. Delay in doing so will inevitably result in time becoming tight later on. So we say that striking out the defence, if it hadn't been struck out already, would have been a wholly disproportionate step for the judge to take in the circumstances.
Just to go off on tangents for one moment, you weren't in the event relieved of your disclosure obligations, as I understand it.
No.
So you presumably did comply.
There's a further judgment. The judge orders that being debarred is no excuse for not complying. The defendants have to comply, and they carried on complying with their disclosure obligation.
And is there any evidence as to what that produced?
Not in the bundle, but my instructions are that as a result of difficulties in downloading it, the other side didn't actually look at it.
Yeah.
So,
and just again, to get a scale of things, you've referred to the disclosure which your side had given earlier. And we've got obviously a schedule, but how many documents had been disclosed, or is that not possible to say?
I think it probably is, but not by me now. I'll have to come back to Your Lordship on that, having taken instructions. I'm afraid I don't know, and I don't think the number is in the appeal bundle, but I can take instructions. Presumably it can then be agreed between the parties. My Lords, I don't know if Your Lordships want to go by the real time or the clock time.
Well, I don't mind. Have you just come to a convenient moment?
That's the end of what I was going to say on Appeal 1. Next topic is Appeal 2.
If you're going to move on to Appeal 2, that probably is a convenient time to stop. All right. Well, I'll go by real time. Say 5 to 2.